public defender, Philip Dube. And Philip, you know, this judge has taken a lot of flack, Philip, for being a pro-defense judge, that he's biased in favor of the defense. Today was a great day for the state, and I thought he was rather liberal in allowing some of these lesser included. So I want to get your thoughts on what's being included now in the case for this jury to consider.
Well, at issue for this defendant is whether or not he acted in lawful self-defense, right? And unfortunately, you lose that privilege if you are, in fact, what we call the provocateur. In other words, if you create the circumstances that causes you to use self-defense, and in this case, it's deadly self-defense. And unfortunately, the judge gave the jury that instruction that if they find that he was, in fact, the initial aggressor, the one who provoked the entire shootout, if you will, then the jury can disregard that self-defense and convict him of the underlying homicide. That's his legal dilemma. What I found really interesting is how the judge went through that consent process to get an on-the-record consent from Kyle Rittenhouse directly, allowing his lawyer to ask for these lesser included offenses. And for viewers, there was a revolutionary change in Sixth Amendment right to counsel, effective assistance of counsel by the U.S. Supreme Court back in 2018. It was called McCoy versus Louisiana, where the defendant has the right to tell his lawyer not to urge guilt on anything. The defendant has the right to go for broke, if you will, to go for all or nothing. And if his lawyer is urging a jury to convict of a lesser, that violates his rights to due process and effective assistance of counsel. So the judge took care to get Kyle's consent on the record. Now, unfortunately, these lessers carry a boatload of time.
Yes,
these are not petty offenses.
No, they're not. And you know, it's interesting. I want to look at one just as an instructive for our viewers. Let's call up the one for Anthony Huber. All right, now Anthony Huber, you count four. He has first-degree intentional homicide was the charge originally. The lesser included is second-degree intentional homicide, and then there's another one they can consider, first-degree reckless homicide. The second-degree intentional is interesting, and I want to get your thoughts on this, because what it allows this jury to do is say, hey, we do believe that, in fact, he might have believed reasonably that he was under attack and was facing some sort of deadly harm, but his response was unreasonable, maybe beyond what it should have been. And we know that in that particular confrontation, there was a skateboard. We know how you feel about skateboards, but there was a skateboard, and then, of course, that was just after Jumpman had jumped on him as well. So I want to get your thoughts on whether those charges may create an opportunity for this jury to find him guilty of something.
Well, first of all, the prosecution has to prove that as to that particular victim or complaining witness, he's not a victim yet under the law, right?
That's right. Uh-oh, I think we lost Philip there. All right, we had a freeze, you know, in these days of electronics, things happen. We'll get that taken care of. Actually, I'm understanding it's taken care of already. Go ahead, Philip. So begin at the beginning, because we lost you very early on.
No, I was going to say that the prosecution has to show as to that particular victim or complaining witness, you know, if we're going to honor the word ban from this judge, because he hasn't been convicted yet, that Kyle acted in utter disregard for human life. And in other words, recklessly. That's what that means. And recklessly also means that Kyle created an objectively unreasonable and substantial risk of great bodily injury or death. So the question for the jury is going to be, A, was it in utter disregard, and did Kyle create it? If, in fact, the complaining witness created it and Kyle reacted to it under a privilege of self-defense, then, you know, the jury can still find him not guilty. Now, on the other hand, if they do find that it was in utter disregard for human life, he can go down on that second degree, and it carries a boatload of time.
Yes, it does indeed, up to 60 years. So it's not life, but still a considerable amount of time. All right, we're going to come back and talk about that.